Hello and welcome all to our channel. Today we are diving deep into a crucial policy. Before we do that, I'd like to introduce myself. My name is Sushila and this is Legal Darpan presented to you by PRATHAM Test Prep. So today we are diving deep into a crucial policy that could reshape India's legal landscape, and the policy is the National Litigation Policy. Whether you are a law student, a practicing lawyer, or just a concerned citizen, this policy has far-reaching implications for our judicial system and access to justice. So let's get started. Now, let's start with some context before we dive deep into the litigation policy. Now, India's legal system is notorious for its backlogs. As of 2024, over 4.5 crore cases are pending in various courts with various levels across the country. But here's the kicker. The government itself is the largest litigant, responsible for a staggering 73% of cases admitted by Supreme Court. Now this situation isn't just a statistics, it has real world consequences. It means delayed justice, increased cost, a tremendous burden on our judicial system. It is against this backdrop that the national litigation policy was first conceived. Now the national litigation policy isn't new. It was first introduced in 2010 under the UPA government with the aim of making government a more responsible litigant. However, like many well-intentioned policy, it remained largely on paper. Now fast forward to 2024, on June 11 this year, the policy was revived by the current government as part of its 100-day agenda. On June 11, the Law Minister Arjun Ram Meghwal signed off a new version of the policy, signaling a renewed commitment to addressing this critical issue. But what exactly it is and why should we care? The NLP aims to transform the government into an efficient and responsible litigant. Now you might be wondering why focus on the government. Well, here's a startling fact. The government is the largest litigant, like I've already said, which is responsible for a staggering 73% of cases admitted by the Supreme Court. This policy is a crucial step towards reducing the enormous backlogs in our courts and ensuring fast delivery of justice. But before we dive into the details, let's understand the current state of affairs in our judicial system. As of 2024, we are looking at a daunting number of pending cases across all levels of our judiciary, approximately 50 million cases. Now let that sink in for a moment. 50 million cases waiting for a resolution. Breaking it down, the Supreme Court currently has 83,530 pending cases. The High Courts across the country are dealing with 60.62 lakh pending cases, and the district and subordinate courts are grappling with 4.41 crore pending cases. In total, there are over 5 crore cases pending in the country across different courts. This massive backlog of cases is the biggest challenge which is faced by the Indian judiciary today. The reason for this pendency include abuse of legal procedures, with lawyers using tactics like repeated adjournments, unrelated oral arguments, and other such tactics to delay proceedings. Another one of the main issues that is there is vacant positions of judges. So according to certain data, that the number of seats that are there, the number of judges for those seats are way less right now. So vacant positions of judges is another key factor, as the sanctioned strength of judge has not been ever fully filled. But here's where it gets interesting. A significant portion of these cases involve government as a party. We are talking about everything from land acquisition disputes to service matters of government employees. The situation which is there today, the pendency of over almost 5 crore cases, it did not develop overnight. It's been growing. It's been a growing concern for decades. Like we can see, since the currently the policy that we are talking about, this policy was came in picture in 2010. So we see that is one of the things that we can see, that this is a growing concern. Another way to see that it is a growing concern is rise in alternative dispute redressal mechanism. Just because the government already had, the courts already had so many pending cases, commercial arbitration, mediation, they've all become very popular. So this issue that has been a growing concern for decades is recognized by both the judiciary and the government. In fact, let's look at some landmark cases that highlighted this issue. So in 2003, in the case of Chief Conservator of Forest versus Collector, the Supreme Court made a crucial observation. It ordered the government to develop a mechanism to resolve interdepartmental disputes at the government level itself, rather than bringing them to the court. This judgment was a wake-up call highlighting the need for comprehensive policy to manage government litigation. Secondly, in the case of Lalita Kumari versus Government of Uttar Pradesh in 2013, the court laid down guidelines for FIR registration, which have implications for how the government approaches criminal cases. These judgments underscore the judiciary's long-standing concern with the government litigation practices. So, what does exactly the national litigation policy aim to do? At its core, there are three main objectives that are there. Firstly, to reduce the average pendency time of cases from 15 years to 33 years. Yes, you heard that right. Currently, it takes an average of 15 years for a case to be resolved. So, one of the objectives is from 15 years to keep the average pendency time to 3 years. Secondly, the national litigation policy aims to transform the government into an efficient litigant. This means the government should only pursue cases that have merit and avoid unnecessary litigation. Thirdly, the NLP's objective is to ensure responsible litigation practices. This involves being truthful in the court, avoiding technical points just to delay cases, and prioritizing cases related to welfare legislation and social reform. But how does the policy plan to achieve these ambitious goals? Let's break it down. The NLP introduces several key features. Firstly, there is a priority review. All pending cases are under this. All pending cases involving the government will be reviewed on a priority basis. This means assessing each case to determine if it's worth pursuing or if it can be resolved outside court. Secondly, monitoring mechanism. A robust system will be put in place to monitor important cases and avoid delays. This could involve regular reporting and reviews at various levels of government. Thirdly, one of the key features is appointment of departmental law officers. Each government department will have dedicated law officers. These officers will be responsible for taking a holistic view of litigation, both when filing a new case and defending the existing one. Another key another key feature that is there is alternative dispute redressal. The policy encourages the use of mediation and arbitration to resolve disputes, especially in cases between different government departments. We knew that for commercial issues, arbitration was anyways encouraged, arbitration and mediation were anyways encouraged. But now through this national litigation policy, what we can see that for issues that are there in government departments between each other, they should also they are encouraged to approach arbitration or mediation. Now, we have talked again and again that government should be a responsible litigant and efficient litigant. Now let's dig deeper into what the policy means by efficient and responsible litigant. An efficient litigant, according to the national litigation policy, is the one that is represented by competent legal professionals. the one that focuses on the core issues of litigation and manages cases in a coordinated and time-bound manner, and pursues good cases and avoids unnecessary litigation. So this is an efficient litigant. On the other hand, a responsible litigant is a litigant who avoids false pleas and technical points. A responsible litigant is one who presents correct facts and all the relevant documents to the court and does not attempt to conceal information or mislead the court. A responsible litigant prioritizes cases related to welfare legislation and social reform over any other. Now, by embodying these principles, the government aims to significantly reduce the contribution to the case log and improve the overall efficiency of the judicial system. Now, the government here, considering that 73% of the cases that are pending are because of some interdepartmental issues or some welfare legislation. So the government is encouraged to be an efficient and responsible litigant so that they do not waste the court's time and everything is done in time-bound manner. Now, as of now, the National Litigation Policy is a document that has been approved by the Law Ministry and is awaiting the Cabinet approval. So once approved, the real work begins. If successfully implemented, the National Litigation Policy would have far-reaching effects such as reduced court backlog, cost savings and improved governance. Now, as we wrap it, it's clear that the National Litigation Policy has the potential to be a game changer for India's justice system. However, its success will depend on the effective implementation, regular monitoring and a genuine commitment from all levels of government as well as judiciary. So thank you so much for staying with us through this deep dive into national litigation policy. As citizens, it's crucial we understand and engage with policies that can significantly impact our access to justice. If you found this video informative, please like, share and subscribe to our channel for more in-depth analysis of important policies and legal issues. Until next time, this is Sushila signing off. Stay informed, stay engaged and have a great day.